The ripples from the 2023 general elections are still being talked about till now. With the handover to a new government less than 49 days away, opposing parties are still contesting the results from electoral process. It is all down to the judiciary to decide, but some people have expressed lack of confidence in the legal system. There is the argument about a candidate needing to secure 25% of votes in the Federal Capital Territory, FCT, to win a presidential election in the country, which the Independent National Electoral Commission, INEC, has refuted. Joining us on this show to discuss the general election conduct and what Nigeria can improve upon and learn from is Mike Igini, former Akwa Ibom resident electoral commissioner of INEC. Welcome to the morning show, Mike Igini, former commissioner INEC.
Good morning.
Good morning.
Good morning, Dr. Abati and Ayo, and thanks for having me this morning.
Well, I'm sure many of our viewers will be excited seeing you because they've been asking after you. They've been saying, where is Mike Igini, who used to analyze elections before the elections and, the pyramid and beavers as a game changer and calling on Nigerians to go out and vote and how technology would transform the Nigerian democratic process. Well, they said the beavers and the IREV and the game changer didn't quite work as you projected. So they're asking you, where is that pyramid? And I should ask you, how market? After February 25.
Thank you very much, Dr. Abati, for having me. Even in the Bible, we are told that there is time and season for everything. There's a period we call pre-election period, where we have to educate fellow citizens on sound knowledge of democracy and democratic process. There is also the second phase, which is the election period itself, where the election will have to be conducted such that all that we have said have to put to tests. After that stage, the final stage is the stage where we are right now. And that is, given what we have in our country, without talking about the judiciary having to step in to look at how the issues that have been brought before them. So, in this regard, where we are now is a period for the courts to look into the outcome of the elections. I want to say that in the next time of my life, there's life after this time, and I'm asked, what kind of profession would you want to be? I will proudly say that I want to be a lawyer. But this time around, or then, I would rather go to the bench so that I can make do what Karl Popper in his book, Open Society and Its Enemies, where I will wait for those whose action or inaction trying to undermine the integrity and public confidence in our institution. So where we are right now, Dr. Abati, as you know very well, in the best of our tradition as a lawyer, is where all who participated in the election, analysts, citizens, stakeholders, one institution to which all must bow is the judiciary. This is where we are at the moment. Therefore, issues that have to do with conformity to or deviation from established norms, rules, and procedure are already now before the court. And the court, I believe, judges are immediately qualified to look into those matters. But today, my engagement as part of your background is the fact that both members of the bench and the bar, those who have either retired or still serving, and those of us in the system. And as all of you have always known, before I went into INEC, or the period I was in INEC, and even after, my clarion call had only been my constituency. Those who have been following me would have read my interviews, years ago, talking about my constituency, that in any democracy, the last line of defense of democracy and the rule of law remains the judiciary. Now, what I want to say today in this engagement, and I hope we have enough time, is to let Nigerians and the whole world know, particularly citizens of this country, that whatever we want to make of our country is clearly in our hands. Because this country, Nigeria, with all the human and material resources, all that's required is leadership. And that when we get the leadership question right in Nigeria, the speed with which Nigeria will attain greatness will be like the speed of the rocket. Now, talking about what is going on, because clearly we have to be highly, highly restrained, but there are a lot to speak about the role of the judiciary. And my starting point this morning is to give a context to the conversation we're going to have this morning in terms of the expanding empire of the courts, the judiciary, in political matter, and the illusion that, which of course is quite indicative of the collapse of politics, and the illusion that the court can come up to fill the void, which is not possible. In any case, what you can only do is to damage our judiciary. Now, Dr. Abati, history is the graveyard for contending opinions. Today, we are now in court over the election that will be conducted. Now, what can we learn? What message do we need to give to ourselves with respect to the ongoing tribunal that's ongoing, having regard to what happened in the US, in United Kingdom, particularly, which is going to be my major reference point in this conversation today. Dr. Abadi, it should be noted, by way of giving this background information, that the United Kingdom, that today is one of the countries that all our people, they go to. In fact, after Nigeria, they go to the UK. It should be noted that even the UK that introduced Nigeria to election rigging for a period of 99 years, almost 100 years, there have been no post-election adjudication in the United Kingdom. Why? At the beginning of the practice of democracy in the 19th century, when election rigging, vote buying, because on record, electoral historians have documented, evidence showing clearly that the UK, America, Russia, Latin American countries, particularly the UK and US, were the most notorious countries for vote buying in the 19th century. And what did they do? At that time, the concern was that they were using landlords, they were using employers of labor, there was voter intimidation, and of course, vote buying. Election was not a one-day affair. Election was for several days. In order to deal with issues about vote buying, to deal with electoral manipulation in England, they reduced election to a day event by virtue of the 1832 Act. Now the question was, when there was fraud, manipulation, vote buying, what was the response? How was petition treated? Election petition, initially in England, was never entertained by the court of law. What was the reason? The reason was that if politicians in England could buy votes, could buy landlords, could buy employer labor to compel people to vote, that there was no way they would not do that in the judiciary. That would lead to the capture of the judiciary in England. They now said, look, we must not allow that to happen because politicians are capable of doing that. So they declined that the court should not entertain election petition in England because it will lead to what we call judicial capture. They will corrupt judges. They will have judges in their pocket in England. That was why they took that decision. And so what happened? They said all petitions should be taken to the parliament. Now, in parliament, because of majority and minority situation in the parliament, petitions from opposition party never saw justice, never saw the light of the day. And that went on for several decades in UK. When it got to a point, at that time, as at 1832, they now realized that the only way to go is to now to go back to a different habitat, to go back to the court. But to do so, what did they do in England? They decided that the very reason why they didn't want court to entertain what they call election petition, that they need to protect judiciary, because without the rule of law, without an independent judiciary, it will be difficult, if not impossible, to sustain democracy. And so what did they do? At that time, the Australian people have already discovered what we call the secret balloting, because remember, Dr. Abati, that voting historically was an open balloting system before now. It was when the Australian people now came up in 1856 with the what they call the Secret Ballot Act that was resisted in England, was resisted in United Kingdom. But when they now decided that, look, see, there's no electoral justice in England, that the matter must go back to the court, that led to the 1872 Act, the 1872 Secret Ballot Act of 1872. That also added to it what you call consequence for any politician who have with either their agent, because just as we have agent here, they also had agent in England, that if you are found for election rigging, you will be expelled from parliament and also banned from participating in politics for 6 years. Even despite that, there were also evidence that what was going on. They now passed the 1883 Act that placed a ban for life from participating in politics.
All right.
When they did that, it was at that point that the matter was now just land on it. The matter was now taken to the court in England. Now, in England, the judges were conscious. They were very mindful of their integrity of the judiciary. And that is why in England, politicians are afraid of the judiciary. They are afraid of judges because the judiciary can never be a safe haven. So all matters that came to the court, they were so treated strictly to discourage people coming to the court so that people can return back to the polling way. That is why for a period of 99 years, there have been no post-election adjudication until 2010, when the Liberal Democrat brought a kind of when they came up and won election and actually disrupted the process for a period of 99 years. So the question is, why is it that in our country we continue to go to the court with all the negative perception that is now surrounding our judiciary? So,
all right, Mr. Igini. Okay, thank you very much for that opener. Very important for laying the foundation for our conversation this morning. If we hear you right, are you saying that the court or the judiciary should not be dependent on with regards to electoral matters? But before you respond to that, that's just to clarify what you've said. The reason why people would go to court, and even the APC who won the presidential election kept egging their opposition or their opponents to go to court, because the belief is that if you're not satisfied with the conduct of the elections, or perhaps certain aspects of the elections or the emergence of the winner, then you have your right to go to court. If the elections are conducted free, fair, and widely considered credible, then the issues or the basis for a petition would not even be found. I'd like you to respond on these grounds to INEC's response, petition response to the PDP's petition response, saying that BVAS was not designed for the immediate transmission of results, or to collation centers? Because you spoke a lot about beavers before the elections, and what a number of Nigerians had been assured was that beavers was the game changer. It was going to make the elections as transparent as possible. In their response as well, they mentioned that IREV, that's the, that IREV was not designed for collation of results either, which is contrary to what a number of people had believed and what you had also, said when you were here before the elections. I'd like to get your thoughts on that. Is INEC moving away from what they initially said, or are they moving away from what they initially said, or has this been the case right from time? Was this your understanding as well?
Ayo, thank you very much. Again, let me restate a part of my opening remarks about the fact that issues of conformity to or deviation from established norms, the Electoral Act, regulations, and guidelines are already now the issues before the tribunals. And as a lawyer, those are domains which will leave for them now. But the most important message, which is part of this engagement this morning, is that the judges, the judiciary, must be mindful of its place in the affairs of our society, particularly in the practice of democracy. And that is why I am given the historical background. It is not because that in all human activities, when there is disputes, the place to go to is the court of law. But I have said that the judiciary in England, judges in England, they were mindful of the fact that if the court of law is now made to answer political questions, such as who is a candidate, the political party, as we have seen, with all the aberration we saw during the political party primaries, the fear in England was that there would be a capture of the judiciary. Today, in our country, you could see politicians bragging all over the place, something that is unheard of in England, of judges, their friends, that they can do whatever they get. They say go to court. That is what they tell you every time. The reason why that has been so, which is the lesson I want us to draw from the experience in the United Kingdom, was that judges were so strict to discourage people to come to the court. That is, by delivering justice according to the law, both substantive and procedural. Whenever there's a violation of a procedure, you'll be held accountable. Judges, the judiciary, held political elite accountable in England. And that's why they are afraid of judiciary in England. They are afraid of judges in England. But in Nigeria, those who willfully go out to violate the electoral process, to undermine the integrity of public institutions, they are the first to tell you that you should go to court. So the question now is for judges, is for the judiciary to reflect on this. Why is it that people gleefully violate the law and they tell their opponent, go to court? This is the lesson that we must learn. That is to say that today you are the last line of defense in defense of democracy and the rule of law. The judiciary must stand tall and mighty in defense of the rule of law and the process. That is the message.
Yes, you've been very consistent in articulating that message, even before the election. The responsibility of the judiciary to build trust, to build confidence, and to dispense justice. But we don't have an alternative to the judiciary that we have. Even the Electoral Act 2022 makes it clear in Section 149. If you are aggrieved, go to court. That's even what the Electoral Act talks about. But I think what we've been trying to do is to get you to offer an assessment of the elections as conducted by INEC after the process. Because before the election, we all had expectations. So what we really want to listen to is your assessment of specific issues in terms of the conduct of the election. And that is without prejudice whatsoever to the issues for determination before the various tribunals, which have not even given notice of hearing anyway. So it's not just sub judice. We can still do a post-mortem. We want you to attempt a post-mortem. And then we can continue with the judiciary.
Yes, Dr. Abati, you know, I said there are three broad phases of the conduct of election. As a matter of fact, the 2023 election process is not yet ended. So we are now at the level of the judiciary. And thank God that you have also reminded viewers, and all of you are all my living witnesses, that all the issues that I needed to speak about, to put ahead, like some of the issues we talk about, 25% and all of that, those were issues I spoke about, not only in the 2023 election. In 2019, I presented even a table to show the direction, the things that are expected. Now, in terms of assessment, you also recall that the Arise Television, channels, AIT, TVC Continental, these are television that provided a platform for me to speak, to engage free without paying a dime. And after the election, you recall that 2 weeks after the presidential election, I also spoke and I expressed my concern about the fact that my votary had only been the process. That if the process is seem acceptable, at least by majority of people, the outcome will go without fuse. And that the whole design of the innovation that we have been working on for years, particularly those provisions that were resisted for 20 years, that have now changed under the 2022 Act, were all intended to ensure that at the end of the election, that the vote of the Nigerian people should be determined finally and conclusively at the polling unit, not in the court of law. Not in the court of law. My reference to the UK was how judiciary discouraged politicians from coming to the court by asking people to go to the polling unit, go to the police station. Let that be determined finally and conclusively. Today, Dr. Abati, despite all of that, we have now found ourselves in the tribunal across the country, to the extent that even the innovations that we have developed, that have been used to conduct over 105 elections, many of you were not even challenged and all that. But because of issue of deviation from conformity to the election, particularly what we saw in the second phase of election, where it was a case of a free-for-all. Do whatever you like. You can go to court. Now, if you look at what is happening now, as we speak, Dr. Abati, when I talk about the implication why we must move away, why election must end finally at the polling unit, is the fact that as we speak, Dr. Abati, because of this now, look at Section 285. Section 285 was actually an amendment that came in on the 6th of January 2011 to streamline the time within which matters will be determined in court, where you said the first leg is 180 days, Court of Appeal is 60 days, Supreme Court 60 days. You are the only country in the world that is having this kind of experience, that you spend half a year allocated for the first stage of tribunal. And that particularly look at that of governors. For someone to be a governor in Nigeria, you go through 4 stages. INEC, after INEC, you go to that of the tribunal. From tribunal, go to the appeal. From appeal, go to Supreme Court. This is where we are. Now, if you look at the timeline with the innovations in INEC, unlike before, where, for instance, to make a register of voters, you have to make photocopies upon photocopies. With the development of the back end or total number accreditation, to get a register of voters now is a matter of seconds. Why do we still need this long period? Just one example, that why using that, we don't need that anymore. It means that, for example, what happened, look at what happened in Kenya. Within 2 weeks, that is done. In Mexico, within 14 days. In Ghana, same thing. We don't even need that 285 days. But these are debates. These are arguments that we have made long before this election. But it's a case of the far corner. No longer listen to the far corner. That's the problem we have. Because we don't need that. Because we can return back to where we were in 1979, in 1983, where people, which of course that's not the law at the moment. The law at the moment is that all those who have House of Assembly, House of Rep, governorship, presidential, whoever have been returned, we have to be sworn in. Then you have to go to court, where you are going to spend 6.5. Now, the implication of this are as follows. I'm not quickly saying this, which is the reason why I'm worried, and I've been saying this over the years. As we speak today, Dr. Abati, because of this huge nature of election petition, all the judges that have now been selected to be in the tribunal, all their civil and criminal docket are now on hold. Cases that have been off for over 20 years, 15 years, as we speak now, they are going to be on hold in abeyance for the next 6 months because the judges are on a video tribunal. Furthermore, cases of those who are require what they call fundamental enforcement of human rights. Right now, you cannot have that done because most of the judges are now in the tribunal sitting. Also, prisoners, those who have been in correctional center that have been having bail applications that have been pending, they are now on hold. All of that cannot be attended to as we speak right now because everybody in tribunal. Commercial business matters, commercial matters transactions in the country today, they are on hold. Nothing can go on. Investment decision is also on hold until all these matters are resolved. This is not the way we should go. We are told that with the direction of the innovations, of the technology in the system, or to ensure that immediately after election, let the business of governance kickstart immediately. Just last week about it. Last week, somebody called me from the US that a group of consortium who are coming, they've been planning to come to Nigeria since last year. They put the entire business plan that will involve millions of dollars investment in a state in Nigeria. But they said it will be after the election. After the election, now the Nigerian counterpart was asking his foreigner to now come. Oh, they said, look, we cannot come because we understand that your election is not yet over. We cannot bring the huge financial capital to Nigeria on account of that. And now the Nigerian counterpart was telling them that, look, it was a matter of a week to be over and so on and so forth. He didn't know that his counterpart had done his own due diligence. And they told him that, look, it will take 6 months. It was on the basis of that that he called me and he put me on speaker. I didn't know, thinking that I would say something different from what he'd been told. And I confirmed to him that for governorship, it will take 6 months. At the Court of Appeal, it will take 60 days. Supreme Court, 60 days. That was what I put that on hold. So what is going on is that to the core, when I refer to the UK, everything was done by Judge.
Honorable Igini, let me come in here because I'd still like for you to respond to Dr. Bati's question and the question I'd answered earlier. I just want to make it a bit more specific again. We're talking about your assessment of the elections, very specifically around areas that you yourself had spoken about before the elections. So I'd like, BVAS, IREV didn't work, well, IREV didn't work in terms of transmission of results on the day, especially for the presidential results. And INEC put it down to technical glitches. Before the elections, you had talked about you'd given us details of how much had gone into the creation of BVAS and how secure it was. And the word that kept coming out was that it was a game changer. In fact, a number of people said that inspired them to go out to vote because they felt that their vote would be valid. It would be a transparent process, so their votes would count. I want you to tell us, what do you think could have happened? What could these technical glitches have been, despite the huge budget that was committed to this process and also the human power that was also committed to this process and your confidence in BVAS in itself? I'd like you to specifically speak to that, please. And also, when you look at the assessment, even with regards to some of the issues that INEC encountered, late start, some areas, lack of preparation, adequate preparation, violence, despite security operatives' assurances, those are the things that people want to hear you speak about, especially from your experience as a former resident electoral commissioner. At least you have an insight into how elections are run right from the, from inside.
Ayo, what is it that I have not said? People should just go back to the interview I had with Charles Nyagulu. I said everything that I needed to say. I have made it clear to everybody that this is not the time for people like us to be talking about the profound benefit of the BVAS. When we have situations where people were killed, people were prevented from voting, there was ethnic profiling. My family had been in Lagos since the 50s in Surulere. My cousin, who was born in Lagos here, was to be beaten up in Surulere. He married to an Abekuta lady. My sister married to a Yoruba person in this Lagos. These things happened. These were not the things I campaigned about. There was a clarion call. The clarion call was very clear. People should come out because we have used it for 105 elections. Apart from Oshu, for instance, all other elections, they were not challenged in court. What was challenged was about, oh, you are not qualified, you didn't go to this school, all those governorship elections. None was actually challenged on terms of process and procedure. But we all witnessed what happened. And the first interview I ever got was to this, Arise Television. Now you have seen that parties have exchanged briefs in the tribunal. And that's why I said, look, there is not much of thing. I granted interview, both in written form and to everybody, print, electronic. And I made it very clear that I'm still in shock about the behavior, what we saw, that the conduct of political class have not complemented the reform that we have made these years. And it's a tragedy that politicians conducted themselves in the most shameful manner. On the election day, one of our own, a Queen's Counsel, a professor who had very pressing matters outside Nigeria, but he placed Nigeria interest above every other thing. He flew down to the country, to Delta State, to go and vote. What he observed was a crime scene. He called me. That how could this be? We are talking one of the finest, the most celebrated Queen's Counsel we have. One that even the British legal community described as one who, whatever he does not know in law, is not worth knowing. That was what he experienced. So, Ayo, right now, I told you that in the best of our tradition, because I've also seen lately that people are going to specific right now as to what, people have exchanged brief already. I mean, you were asking me to be responding to the Electoral Management Body's response to petitioner's brief. I mean, why should I go into that? I can't go into that. I should not go into that. Let's wait for the court to decide that.
Honorable Igini, I'm sorry I had to interrupt you there to take our correspondence.
Yes, so
please
Ayo, yes, Ayo, that is why I'm of the view that Nigeria cannot be in autarky or best practice around the world. The judiciary, the judges must remain very strict. You must discourage people from seeing judiciary as a safe haven for wrongdoing in our country. Society make progress on the basis of reward and sanction. Right now, briefs have been exchanged. It is not for me now to comment virtually. I mean, my greatest frustration for our country is that even when we see a storm coming, a storm seeing coming should not blind the eye. There are things that we have said over and over and over again, but yet nobody is listening. The rule of law, the first victim of the subversion of democracy is the rule of law. And that's why Judiciary must stand tall and mighty to discourage politicians. How can you be heard in England that a politician will boast in that they will do whatever they will like, they will go to the court in England and they will get what they want? It's unheard of. That was why judges, Jonathan Sampson, the retired Supreme Court Justice of England, warned of the expanding empire of the court on political matters. For anybody to think that the decline of politics can be filled, that void can be filled by judiciary, is a fundamental error. Judges, judiciary, you must prove, show to politicians that our judiciary cannot be. Look, the legal profession, it is one profession that is not just for aching a living at all. It is one that has a special relationship with the society in terms of order. And that's why I said, if I come to this world again, I want to be a lawyer. But this time around, I will be in the bench so that I can wait for the enemies of society and see what they will do. So, Ayo, what happened? Our expectations in terms of not even having to have this huge number of cases in court is largely unmet. What did they expect that this is the way it's going to go if everybody complied with the rules and regulations as we have put in place? Today, why is it that you spend half a year to, what, are we writing new law? We are the only country where we spend so many years to write a law, then we spend half a year to want to interpret the law that we have written. It's a shame.
You've laid out the context, you've made your observations, you challenged the judiciary, but let's now talk about specific recommendations. You refer to Section 285 of the Constitution, where that's what we have in terms of time limitations. 285, 6, 7, 9, you know, and all of that. But there is now a proposal on the table that, look, and this is by Olisa Agbakoba here, that, look, the courts, the tribunals, they can resolve this within 7 days. Okay? But there are people who also have another view who say, well, Section 285 is what it is. That's what the law is. That's what the lawmakers have provided. Are you recommending a constitutional amendment, or do you think, as Agbakoba has recommended, that the judiciary, you know, can just resolve these petitions in 7 days? Is it possible? Considering the fact that you have also pointed out that the courts are overburdened, and there are more urgent cases that will have to be in abeyance. That's one. Number two, we go back to the Waste Commission report. One of the major recommendations in the Waste Commission report is that, look, election matters should be determined before anybody occupies political office after elections. What do you think of that? Three, some people have suggested that there should be a complete reform of the judiciary, and that election petitions don't have to go all the way to the Supreme Court, and that the Supreme Court should just focus more on constitutional matters. So there have been so many of these recommendations. In fact, people say the responsibility of the court should even be to ban any politician that is involved in any act of rigging from getting involved in Nigerian politics for life. So these are some of the things on the table. But what are your own specific recommendations?
Thank you, Dr. Abati. Let's start from the issue about banning for life. That was with the measure they took in England. And that deter politicians by virtue of the 1883 Act, where you'll be banned for life from participating in politics. Number two, with respect to the views of the learned's sake, Olisa Agbakoba, is correct to the extent that he's speaking from the point of view of the current reforms in the system. As I mentioned to you before, it will take days when we're having purely manual system for INEC, when you seek for citizenship of register of voters, to make photocopies of copies upon copies. It will take days, no light, there's no diesel, there's no that. But right now, the Electoral Act have made it clear that it must be provided in an electronic form. So in a matter of seconds, you will get that register. So you don't need much time to do that. Furthermore, and perhaps far more important, everyone who has been given job as a lawyer by INEC since 2010, that I went to the commission, all of them who are out there can confirm what I'm going to say here. And that is that from 2011, Dr. Abati, when we started these innovations, and more recently, whenever you are given a brief by the commission, and you come to me where I work, I made it clear to you that, look, in my jurisdiction, election was conducted. Whoever that have been returned, barring information on evidence that may not be known to me and to the commission, but if they are able to provide those evidence, we will help them in court to ensure that election is annulled. Ask all lawyers that have always come. I issue them a separate letter. Because to key in what Olisa Agbakoba is talking about, and that is that the evidential axiom under the Evidence Act, Section 131, we say that whoever asserts the existence of certain fact must prove. Is the reason why people believe that they can do whatever they do and they go to court and say, go to court, come and prove. But the whole essence of the innovation, Dr. Abati, is to return, as I did, I will call them, that the honor to prove, I am a commissioner. I presided over this election. Now there are issues with respect to the return that have been made under my watch. I have a duty, by virtue of you reading clearly, and this is what the judges need to do. They need to read very clearly Section 136 of the Evidence Act, Section 140 of the Evidence Act, and for the purpose of this public engagement we are having today, which is the reason why I said judiciary must stand tall and mighty. Section 131, Section 136 of the Evidence Act, which is what Olisa Agbakwa is saying, because the whole of innovation is to return the duty, the responsibility to explain how a return is made to me. That was what I used to tell them, because I should be the one to explain how this return were made. Because that section says clearly, subsection 2 of 36, that in considering the amount of evidence required to shift the burden of proof, regard shall be had to by the court or opportunity of the party who is in possession of the evidence in proving what has happened. That is very clear. Go to section 140. They can go and read it. What is the point here? To close on Olisa Agbakwa's views on the time within which to finish this matter. It is that, as I told them, look, here in Akwa Ibom, here in Edo State, here in Cross River, I was the one that presided over the procedure, the process, recruited ad hoc staff, trained them, the technology that have been used, the material for the election, they are in my possession. I'm in a better position to explain how I made those returns. Go and ask all lawyers. They can confirm what I am telling you, Dr. Abati, that this is where it will go so timelessly. Because if the integrity of the process that I presided over is called to question, Dr. Abati, it is unfair to be, you know, like what is going on right now, challenging people talking about the person who have been returned, both petitioner and respondent. These are innocent people as far as I'm concerned. Because if you ask any person who have been returned as a member of the House of Assembly, House of Reps, Senate, and any other governorship and other, they don't even understand those things. It is the umpire, it is myself who presided over that have a better knowledge. I'm in possession of certain facts that are necessary to throw light on what has happened. So Agbakwa is right to the extent that having regard to the innovation, we may not need that. In any case, Section 285 says within. It didn't say it must. I mean, how do you hear that about that half a year? We need half a year. Are we writing a new law? That is respect to that. Now, furthermore, on the issue of, but try to remind me of the other two issues.
Quickly,
dealing with
the Waste Commission saying elections petitions should be determined before anybody occupies office. But we have just about 2 minutes or 1 minute to go.
I would do that very quickly. Abati, look, we're in a country where whatever works for our country, we don't want to do it again. In 1979, in 1983, people were election petitions were resolved before people were sworn. When you do that, everybody will be up and doing. Nobody want to filibuster, all right, to see that it is done. Because if you don't do that, people go into office and begin to use public money. When you hear about billions as legal fees going on, where do they get that money from? Finally, on Uwais. Look, I've been hearing people talking about Uwais report. Abati, Dr. Abati, is so fortunate that even though we talk about it, let me be informed here that the former Attorney General and the late NAFDAC woman, Akuyili, they were members of that committee. Do you know that there was no white paper? That the entire profound recommendation were rejected. No bill ever sent to the National Assembly. It was only President Goodluck Jonathan, when he came on board, because of his quest for credible election, he appointed Professor Jega, who was a member of that committee. And what they did was, what we did was to now start implementing it. We started the implementation by first doing what we call the biometric compilation of register. That was one of the profound commendations. So I agree totally that for sanity to prevail, this is a proposal for the future, not for now. It's for the future. But for now, this is the position of the law. But for the future, it is better, cleaner, that disputes are resolved before people are sworn in, so that the business of governance can take place immediately.
Thank you very much, Honorable Mike Igini, for joining us on the morning show today.